Before this hearing ends, one decision could determine whether a man accused of capital murder ever walks free before trial or remains behind bars. A family pleads for mercy. The defense calls the bond excessive, while prosecutors warn the court that the community is still in danger. Dada's explosive arguments collide with the judge's duty to protect public safety. Every statement carries life-changing consequences. Stay until the very end, because the judge's final ruling will reveal whether justice favors freedom or absolute caution.
Yes, sir.
And presently, he has a bond that's approximately $10 million. Is that right?
Yes, sir.
And have you all attempted to make that $10 million bond?
No, sir.
And the $10 million bond, that was set by a magistrate like early on in this process?
Yes, sir.
And also his other bond for the aggravated assault case was raised. Is that correct?
Yes, sir.
From what to what?
25,000, if I'm not mistaken, to 100,000.
To 100,000?
Yes, sir.
Okay, so he has approximately $10,100,000 worth of bond.
Yes.
Okay, and if the judge sees fit to place his bond like at maybe $50,000, do you have family, friends who put up the property like collateral as well as money in order to secure the bond?
Yes.
Would you be willing to co-sign on the bond?
Yes.
Do you have other family members that would be willing to co-sign on the bond?
Yes.
Have you been in touch with the bond fund, and do you know of a bond fund that would be willing to go along with the bond for you?
Yes, he's in good standings with his bond.
I'm sorry, I can't hear you.
Yes, ma'am. He's in good standings with his bond he had approved.
Okay, so
I still didn't understand what you said at the end.
He in good standings with the.
Oh, he's in good standing. Okay.
Yes, ma'am.
okay. Have you ever known Larry not to appear in court?
No, sir.
And he has, on the other bond that he had for the aggravated assault, did he ever fail, to your knowledge, to come to court?
No, sir.
He always came to
Yes.
court every time,
Yes.
on time. There was never any problem with him showing up in court?
No, sir. There's no problem.
All right. And I passed the witness.
All right. Thank you, Mr. Cashin. Mr. Smith, any questions of this witness? Thank you, ma'am. You can go back and have a seat. Any other witnesses, Mr. Cashin?
No, ma'am, but Your Honor, I would like to point out that there are other family members in the courtroom
Yes,
that
sir.
are of adult age. Tanisha Williams, his daughter, who is present in the courtroom, she would say the same thing that Ms. Anderson just said, as well as his daughter, Lareja Clay, who's also an adult, and she would say the same things and would confirm with what Ms. Angel just now said.
Thank you.
Presently, his bond, which I feel is
Mr. Williams, you can step back around, sir.
Presently, his bond, which I feel was emotionally set at $10 million. I think that is very excessive and is very punitive. And Mr. Williams, although he has had some issues with the courts and the judicial system, he has never, ever failed to appear in court. And I think that because of, I think that his prior attendance in court, his prior taking care of all of his court business shows that he is not ready to flee, he's not ready to run, that he will come to court and face the charges and face whatever the court requires of him. A monitor would be sufficient to maintain his location, like with the GPS. He does need to work, so I would not like to request that he be placed under house arrest, but I think he should be able to have maybe a monitor or maybe some curfew hours as opposed to a $10 million bond. I think a reasonable bond for a case like this should be about $50,000, and I would like to request that the court set his bond at $50,000.
Okay. Mr. Smith?
Judge, the state is opposed to a reduction in the bond. This capital murder is based on the fact that we were coming up for trial. The murder of the victim, who was also the victim in the aggravated assault, occurred very shortly before that was actually going to be called for trial. And the fact that he fled after committing this murder to Houston and had to be located in Houston shows that he is likely to run if given a bond. The family of the victim is also in fear for their lives should he get out of jail, and we'll be ready to proceed to trial as soon as Mr. Cashin is up and ready.
Your Honor, in regards to what Mr. Smith just said, Mr. Williams, when he was located in Houston, was on his way to my office. And that's the reason he was in and around the Houston area, because he was coming to my office to consult with me because he had heard on the news reports about this alleged murder, and so he was coming to talk to me, and he was not in the process of fleeing, but he was in the process of coming to consult with me about the situation. So I think that by alluding to the fact that he was arrested in Houston is like kind of a stretch, because he was attempting to meet me at the office.
All right, so obviously this case is the date of this case precedes any modifications that happened in our legislation this last cycle that have come into law as of yesterday. One of those is actually that it is appropriate, and if someone is out on a bond for a felony offense, and the allegations are that they commit another felony offense, to have no bond, which is something that is more strict instead of more lenient with regard to bonds. I believe the fact that Mr. Williams has come to court when required obviously is nice and great, but the fact that he's the allegations are that, and they're allegations, he hasn't been found guilty, but I am entitled to take into consideration the underlying facts of the case. And so based on the offense that he was charged with initially, the aggravated assault, based on the fact that this new allegation is that the victim or the complaining witness in that case is now the victim in this alleged case, I do not find that it would be in the best interest of our community to grant the motion, and I am going to deny that motion to reduce bond. We will get the case moving as quickly as possible. I get with Mr. Smith, and again, just like we talked about before with regard to any issues, just let me know if there's any issues with regard to discovery, and I'll set it for an announcement in about 30 days,
Yes.
give y'all some time to see where you are.
Yes.
And then again, once it's ready for trial, if it's going to be a trial, we'll get that done as quickly as we can.
Yes.
All right, you can go back with the bailiff.
Thank you.
Good morning. Morning, Ms. Malfino.
Good morning, how are you?
Good, thank you. Let's see. Okay. So, she was ordered a safe P already. Does she go and,
She was unsuccessfully discharged from the aftercare, the Melton House. She left the Melton Center.
so the agreement is to go back to, for relapse? Does it need to be is there a special needs relapse?
Yes,
Okay.
special needs. She's got a lot of underlying.
Sure. Ms. Washington, the best you can, raise your right hand for me, please. Do you swear or affirm the testimony you give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, and will she waive the formal reading of the motion?
Yes, Your Honor.
Ms. Washington, in cause number 23, DCCR 1036, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation September 10th of 2024 for harassment of a public servant, and that was a 2-year deferred probation. Is that correct?
Yes, ma'am.
It alleges you violated your probation. Count 1 alleges that you failed to report as directed to the probation department June 2nd of 2025. And is that true or not true?
True.
Count 2 alleges that you failed to enroll in services at the Spindletop Center. Is that true or not true?
I didn't tell me nothing about the inmates and more services, but I can do it though.
Okay, so we'll do not true for 2. Count 3 alleges that you're behind in your court-assessed fees.
Yes,
Is
ma'am.
that true or not
Yes,
true?
ma'am. True.
True. And then count 4 alleges that you failed to successfully complete the SafeP program, including the aftercare. Is that true?
Yes, that's true.
Okay. Did you enter your pleas of true to counts 1, 3, and 4 freely and voluntarily?
That's right.
And because those counts are actually true.
That's right.
So it's my understanding, Ms. Washington, that probation feels like you still deserve a chance and that you have the ability to take advantage of some services and be successful. I want to make sure you understand from my standpoint. I have no doubt that they have let you know about everything, okay? From the very beginning with regard to SafeP, with regard to any special services through Spindletop. If you don't take advantage of this opportunity this time, and you're back in here because you didn't go and receive services or you don't successfully complete the relapse program at SafeP, we're not going to be talking about keeping you on probation. You understand? You could go to prison for 10 years today for violating your probation. It's that serious. So you need to make sure you take advantage of everything they have to offer you, okay? All right. So
Would the court consider maybe extending?
I'm going to have to, yeah, for sure. It's going to be extended, I would think, by at least 2 years. I'm going to make your probation go longer because you got to go back through SafeP now, so it's going to take longer. So you're going to have to prove that you can be successful, so I'm going to extend your probation.
Okay.
Hold on just a second. So here's another thing that's very important. Your behavior in the jail is something that I find out about. Okay? I get incident reports.
Yeah.
And hang on. And it explains every time you get an incident report, every time you're calling a correctional officer the B word, every time, hang
I want to
on.
know my benefits.
Well, and I understand that there might be some issues, okay? But I want to make sure that you do the best you can
Yes, ma'am.
to follow all of the rules and not be disrespectful
Okay.
to anybody that's in there just doing their job and trying to help, right?
Yes.
They're just going to work every day,
Yeah.
okay? They don't deserve to be treated that way. That includes when you're in SafeP. Because if you get to SafeP and you're on your medicines and everything's correct and you're acting like this, then you're going to end up getting revoked before you ever get out. Does that make sense?
Yes, ma'am.
Okay. So I'm going to find
refused to reduce the multimillion-dollar bond, keeping the capital murder defendant behind bars, while another defendant received one final opportunity to turn her life around through probation instead of prison. These 2 cases prove that every courtroom decision balances justice, accountability, and the safety of the community, and one ruling can change a life forever. What do you think? Did the judge make the right decisions? Or would you have ruled differently if you were on the bench? If you enjoyed this courtroom breakdown, don't forget to like, subscribe, and turn on notifications, and watch our next courtroom case to witness another unforgettable legal battle unfold.